Now, the tribunal into Western Cape Judge President Hlophe is taking a lunch adjournment right now. Lawyers in the 4 legal teams are wrapping up their arguments before the tribunal. Hlophe is charged with gross misconduct for allegedly trying to sway the loyalties of 2 constitutional court judges in favour of former President Jacob Zuma. For more on this, let's speak to Newsroom Africa's Special Projects Editor Dianne Hawker. A very good afternoon to you, Dianne. A very insightful afternoon that we've had so far. If you could just talk us through some of the key arguments that have been made thus far.
Yes, Tammy, I think that for those who may have missed the morning portion, this evidence or this closing argument that we've been hearing now from Advocate Gilbert Marcus has really summed up some of the key issues of the case. Earlier this morning, we did hear from the evidence leader, Advocate Ivy Tenga, and her evidence or her closing arguments, rather, were quite short and to the point. Some of the issues that she raised, she first summarized the evidence and then made the point that if Judge Hlophe had only wanted to come and congratulate Judge Nkabinde, he could have done so at an event which they both attended the night before he went to the Constitutional Court. So she was casting aspersions against what he had said there about why he had actually gone to the Constitutional Court. We then heard from Advocate Thandi Norman, who represents Judge Nkabinde and Judge Jafta. And while she didn't necessarily say which way the ruling should go, she did make a point of trying to clarify what the positions of the 2 judges were and what their evidence was. So there was a lot of going back to the original record and clarifying some of the key issues there. But what we have heard from now is Advocate Gilbert Marcus, who has been going through the evidence in quite a lot of detail. And Advocate Marcus submitted about 55 pages worth of heads of argument, which is essentially the summary of his argument. He submitted that to the tribunal, and along with what he's included in there is some international cases that deal with the issue of how judges' conduct should be handled. He also looks at the UN principles on the judiciary and has also included in their references to the actual code of conduct for judges here in South Africa. So quite a comprehensive representation that we've heard there from Advocate Gilbert Marcus. He is in fact expected to continue after the lunch break, and then we are only meant to hear from Judge Hlophe's legal team this afternoon.
Now, Dianne, throughout the cross-examination earlier on in the week, and even in these closing arguments, the focus somehow seemed to be on intention. What was Judge Hlophe's intent in communicating to the 2 justices? But we also heard here Advocate Gilbert Marcus saying that actually the test is not intent. If you could just talk us through that.
Indeed, Tamia, that was quite one of the points that he made a little bit earlier on, saying that it isn't enough to look at whether Judge Hlophe intended to influence the other 2 judges. And he, in fact, says that when you look at Judge Hlophe's evidence on its own, he believes that it's clear that there was an attempt to influence. He says that the court needs to take a common sense approach when looking at this matter, but also says that it is important to consider that judges are not like ordinary people and that their conduct needs to be beyond reproach, not only while they are at work or working on cases, but in their personal capacity as well. And as a result, he's actually made reference to a recent conduct tribunal case that we had here in South Africa involving Judge Nkola Matata, who was found guilty of misconduct and was disciplined. He wasn't removed from the judiciary, but he did receive a disciplinary sentence. And as a result, Judge Advocate Marcus rather saying that when you look at just what Judge Hlophe has said about his conversations, why he went to the Constitutional Court, why he spoke to the 2 judges, on their own, if you consider them in relation to what should be expected of judges, then that in itself would be problematic. And I think that one of the points that he made that was quite interesting was that if the conversations were overheard by any of the people involved in the Tint Zuma matters, that they would have actually had an issue with what was discussed, because on his version it goes to the principle of the case itself. So it wasn't just talking about legal principles, but in fact had to deal with the content of a case which was under consideration, and that they would have also taken issue with a judge coming from another court to speak to judges of the Constitutional Court to discuss a matter that they hadn't concluded judgment on. So some very interesting points being raised here this morning, important clarifications also coming from Advocate Norman, and also from the evidence leader giving a summary of what they think is important for the tribunal to hear. Tami.
Thank you very much for that, Dianne. That's Dianne Hawker, our special projects editor, who's covering the tribunal.